Okay, hello and welcome to today's webinar, Digitalization Accelerated. The starting point here, as with so much else from the period that's defined our lives recently, is COVID-19. More specifically, it is the impact of COVID-19 on trial processes, disputes, both litigation and arbitration, and the justice system itself. Today we will hear perspectives from the judiciary, the Intellectual Property Office, global arbitration centres, and some of the leading practitioners in Southeast Asia. But before I introduce them, and before we turn to discuss issues in Malaysia, I will start with a statistic, if I may, from the United Kingdom, from the UK's Courts and Tribunals Service. In the last week of March 2020, so just before the lockdowns happened, there were under 1,000 cases heard each day in England and Wales that made use of audio and video technology. So fewer than 1,000 cases by mid-April. That had increased to approximately 3,000 cases per day. And remote hearings have since accounted for over 85% of all cases. I hope I'm reading the data correctly there. But obviously, this shows a rapid and significant change, at least in the UK, where I'm sitting now, in how courts have operated, and quite what this means for the court system in Malaysia, and indeed across Southeast Asia, and of course what it means for businesses in the region will be our subject today. My name is James Wood. I am one of the editors at the Legal 500, and it is my great pleasure to announce a wonderful panel of experts who will be helping us to address this question. Now, our first speaker today is someone who I am sure you all know, and of course saying it's an honour to introduce someone is somewhat overused as a convention, but in this case it is indeed a genuine and true honour. The Honourable Justice Data Mary Lim Thiam San. I will introduce her and then introduce our other speakers before addressing questions to her. So her ladyship read law at the University of Leeds in the UK and was called to the English bar by the Honourable Society of Lincoln's Inn. Her ladyship has also obtained a Masters of Law degree from the University of Western Australia, so very well versed in international law as well as, of course, Malaysian law. Prior to her ladyship's elevation to the bench in 2009, Justice Lim served in various positions in the Attorney General's chambers with specialisation in civil litigation, both public and private law. Her ladyship was also a senior parliamentary draftsperson, Commissioner of Law Revision and Law Reform, and of course the first female state legal advisor to the state of Negeri Sembilan. I hope I'm pronouncing that correctly, Judge. At the High Court, Justice Lim initially sat as a commercial judge before becoming the first judge of the Construction Court in Kuala Lumpur. Her ladyship has made notable contributions to continuing legal education and developing skills for both members of the legal fraternity and the judiciary, whether young or forever young. Justice Lim is a pioneer member of the Faculty of Advocacy Trainers in Malaysia and has remained active in its work for over a decade, both within the country and abroad, including at Keble College, Oxford, Hong Kong, and Singapore. Her ladyship has also delivered lectures on various legal subjects. So on behalf of our audience today and viewers around the world, a humble thank you from us at Legal 500 for joining us for this discussion, Judge. We will also be joined by partners representing GAN Partnership, one of Malaysia's leading law firms. Before I introduce the partners, I will say a few words about the firm for those of you watching from overseas. So GAN Partnership is based in Kuala Lumpur. The firm specialises in dispute resolution, alternative dispute resolution, and intellectual property in both domestic and cross-border matters. It is led by a team of advocates, each of whom has more than 20 years experience in domestic and cross-border disputes, big ticket matters. So very well experienced and very well placed to help us with the subject today. The firm has an increasing focus on arbitration and cross-border disputes. It has wide access to a network of eminent international and local technical consultants and experts, and a multilingual team to draw upon. They are recognised as key dispute resolution practitioners by the Legal 500. So 2 of the intellectual property team members are recognised. So one is a leading individual, the other is a next generation partner, so we have recognised them. And their skills and expertise have further been acknowledged by other leading legal publications. So of course, like all law firms, I'm sure they will regard the Legal 500's recognition as paramount. In August 2020, GAN Partnership was one of 4 Malaysian law firms that was named as Legal Innovator in Asia by the inaugural ALB Trailblazers Awards, alongside some more established international law firms. So they're both a very well established and also an up and coming firm, hugely excited to have them with us today. Speaking on behalf of GAN Partnership will be Bahari Yao. Bahari is ranked in the Legal 500 as a leading individual. I think we described him as undoubtedly very knowledgeable in his field of practice. His commitment, passion, and enthusiasm are commendable. He has received similar, equally glowing commendations from ourselves and others. He has a humble approach, humble but solutions-driven approach to servicing clients, and was awarded External Counsel of the Year by the in-house community in Malaysia, I believe. Bahari brings with him years of litigation experience applied to the field of intellectual property, and he advises on all aspects of IP matters. He's been invited to speak at numerous events, both local and international, from universities, international arbitration centres, national and state bars. He currently serves as a member of the Group Standing Committee for Copyright. That was between 2015, I believe you left that position, Bahari, in 2018. If I'm right, and also of the Asian Patent Attorney Association, the APAA of Malaysia. Welcome, Bahari.
Thank you, James. Thank you.
We will also be hearing from Fu Junliang, JL, partner of GAN Partnership. So Junliang was called to the Malaysian Bar in the year 2000. He's a partner of the firm, of course, and it's the firm he indeed co-founded in 2011. He is a fellow of the Chartered Institute of Arbitrators of the United Kingdom, so CIR. He is a member of the Singapore Institute of Arbitrators, or rather a fellow of the Singapore Institute of Arbitrators and of the Hong Kong Institute of Arbitrators. He's also the chairman of the Malaysian branch of CIR. He sits on the panel of arbitrators and adjudicators of the Asian International Arbitration Centre and is one of the first 10 Malaysian appointees to the panel of arbitrators at the Hainan International Arbitration Court. He also sits on the Securities Industries Dispute Resolution Centre panel of mediators and adjudicators. His practice covers a broad spectrum of engineering, construction, and energy disputes, and he often speaks at conferences and trains with the advocacy training course. In addition, Mr. Fu has authored articles for legal publications, a number of them, including a chapter for international arbitration in the Global Legal Insights series. I will now also introduce our other guest, Ilya Hashim. Ilya is legal officer at the Intellectual Property Corporation of Malaysia, so my IPO. Ilya began her career as a legal officer in the Intellectual Property Corporation of Malaysia in 2012. She was admitted to the Malaysian bar in the same year. She recently graduated with an LLM, business law, from the International Islamic University of Malaysia after obtaining her honours degree, or LLB, from the same university, and also holds a degree in music, a master's degree in music, I believe, from Middlesex University in London. Is that correct, Ilya?
Yeah, I have all that.
That's an interesting background indeed. In her current role at MyIPO, she's responsible for, among other things, providing legal advice to the corporation, drafting the law during any legal review exercise, providing legal assistance during negotiation of free trade agreements for the intellectual property chapter, and representing the Register of Trademarks, Patents, and Industrial Designs in the High Court, Court of Appeal, and the Federal Court of Malaysia. So she no doubt knows Justice Mary Lim already from the other side of the table. We will later be hearing from Annette Magnussen, who is Secretary General of the Arbitration Institute of the Stockholm Chamber of Commerce, and Kevin Nash, who is Deputy Registrar and Centre Director of the Singapore International Arbitration Centre. They will be joining us later today, so I won't introduce them just yet. I will instead stop speaking now and turn over to Justice Mary Lim. Before I do, just a very brief final note from me. Look, this webinar we'll hope to run for around 90 minutes. Let's see if we can rein our speakers in and keep them to that, but it might run over. And of course, we're looking tremendously forward to hearing all their views, but we do also want to hear from you in the audience, whether it's a provocative statement or something you would like to get the panel's opinions on. So please do use the Q&A and chat function to submit your thoughts, and we will try to address them throughout the session. Okay, with that said, I will turn now to Justice Mary Lim. Judge, welcome.
Thank you, James.
Hi.
Good evening, good morning, good afternoon.
Evening, good morning, good afternoon. So look, I started with a statistic drawn from the UK, showing the rise in number of remote hearings that have been taking place over here in London and throughout the United Kingdom. What has the situation been in Malaysia, Judge? I mean, have you seen a significant rise in hearings conducted digitally, or has it been a more gradual change?
Well, James, I'm going to answer that question in a somewhat long way. I'm going to take you and the audience back a little bit and go back to some fundamentals. And I think that's quite important because our journey in the digitization age didn't happen just today or just this year. It's been a journey. So I start this way. I start with the fact that we have always been very conscious of our role, our duty and our oath under Malaysia's written constitution, where access to justice, equality before the law, and the entitlement of all persons to the equal protection of the law are enshrined as part of a person's fundamental liberties. So they are all supposed to be entitled to the equal protection of the law. So the rule of law actually mandates, in fact, directs every member of the judiciary, and that includes myself, to take every step possible and necessary to ensure that that liberty that I just referred to, which is about access to justice, is never compromised, shortchanged, or encumbered, just because we've got technology advanced and digitization of life in the very many respects. We cannot afford to have a complainant of life, be it of criminal or civil justice, unattended for the very simple reason that we, the judiciary, are not prepared, or because we have no infrastructure or the know-how. So speaking entirely for myself, I believe that if that were to happen, that would be a dereliction, and a very serious dereliction of my duty and oath, which is to preserve, protect, and to defend the Constitution. So looking at all of you and all that introduction that you made just now, I'm very much conscious of a Y and now Z generation in taking cognizance of how life and how business and commerce operates. Steps, in fact, in the judiciary have been taken quite early to meet these change of times. If I mention this singer or these singers, I think it's going to reflect where I come from and my era. And there's a singer called Jackson Brown, and he sang the song called Before the Deluge. And there's a singer called Tracy Chapman, and her song is a song called Talking of a Revolution. And both of these songs remind me that if we better change our ways of how justice could be accessed, because we simply have to. Otherwise, we're going to be washed away. So multiple initiatives have been blueprinted to ensure that the administration of justice in this country is actually enhanced and strengthened. Much of it is already in place, but there's still plenty in progress. And we James, actually go back to at least 2009 when we introduced the e-court system. And that system comprised easily about 4 components. We have, I'm going to say that it's the CMS, the CRT, the QMS, and e-filing. The CMS actually stands for case management. So is the documentation part changed? QMS is about where you are in that whole system. The CRT is the court recording and transcription system. So it's actually taking care of the trials and proceedings within the court itself. And to that, we've added e-review with an email system and a hand phone system where WhatsApp messages are exchanged between counsel and the court to make sure that we can get things done electronically. And I understand we now even have a QR code system where you can verify the authenticity of your court documents, and you can do so anywhere. And recently we had e-appellate for the Court of Appeal and the Federal Court, where I am now. And this is where we run the appeals without any hard copies. The occasions where we have to use hard copies are on pleas of counsel for a variety of reasons. And this basically shows that we have had to get ourselves ready more than 10 years back. And I understand we even do mediation online or virtual or cyber settle in some of our courts. And if that's not enough, in February of this year, we had AI as well. And that's in respect of sentencing. We have a Chief Justice of Sabah and Sarawak, then Chief Justice of Sabah and Sarawak, who was extremely tech savvy, and he introduced AI for sentencing in 2 drug cases in a magistrate's court. And I understand there's more in the pipeline. So when I heard about that AI, it terrified me. So, you know, it's digitizing. Digitization is digitization of anything, and that would include me. So that AI actually was a clue to what's next changed. So apart from the structural arrangements that had to be put into place, there were also huge financial commitments. So we've had this more than a decade of preparation. And to that equation, we had to train and prepare the users. And that's not just the judiciary, but we also had to prepare the public, especially the legal fraternity. And I can tell you there was resistance. Quite a few people were dragged, kicking and protesting, I assure you. But for me, more than 10 years down the road, I personally find that I can no longer conduct without the assistance of digitization. To me, there is nothing more helpful than having evidence full dimensional, colored, and interactive. I remembered when I was doing trials, I looked at counsel's copies of documents and they were colored. And I had mine in black and white. And I always asked why I was shortchanged. And I always felt that if we could only bring what happened in the construction site or the particular equipment that was under dispute visually in front of me, it would solve a lot of attempts to try to explain and describe the dispute. So the availability of electronic records to me has played a significant role in resolving disputes, even on demeanor, sequence of witnesses, and even counsel and judge. I mean, we've had complaints of how judges have misbehaved, supposedly misbehaved, or even counsel, and these replays through the CRT system has resolved that. So the system that I've just talked about, I'm still haven't quite got to your answer to answer your question yet, is actually deployed in all levels of litigation, both civil and criminal. And it's for all levels of applications and hearings, interlocutory, full, and appeals. And we found that it has been very useful, and you get a hint of my answer here, that it's been very, very useful, especially for urgent matters. And I personally find that all I need is my laptop, which thankfully they've given me one which is so light I find the iPad even heavier than my PC. So it's so useful and it can be accessed anywhere, anytime. So fast forward now to 2020. And this is where we are on in COVID times. I don't think it's crossed anybody's mind that this is where we will be today. But due to its magnitude, everyone is learning and evolving together. I personally have never seen such a wide-scale exchange, generous exchange of knowledge, skill, and know-how ever, and free. Webinars and digital platforms have become necessary communication lines. You link or be linked or be inked, I think. You either nail it or you be nailed. So Malaysia, so that is now 2020, and Malaysia went into its first lockdown in middle of March this year. We went through a series of movement control orders from MCO to RMCO, which is Recovery Movement Control Order. We've got a conditional movement control order. We are in the second conditional movement control order, and that expires early December. And the judiciary has not been spared. The courts have unfortunately or fortunately not been listed as an essential service under the relevant regulations, unlike, say, New Zealand. So while electronic filing has not been compromised, unfortunately, hearing has been. So while the file and the record of evidence have been digitalized, we haven't done that with counsel or witness or the judge. So that has all remained very much, if not by video conferencing, it's very much physical. So the problem becomes more acute when we're dealing with criminal justice, where remand proceedings, bail applications, and registration of new cases still proceed relentlessly, and where the court officers have to balance between health and safety and dispensation of fair, safe justice. So in the middle of April, Chief Justice then issued a press release responding to the many queries as to whether the courts have stopped operating. Because there was a question as to whether we all then had to stop working. And this is what her ladyship said. The Right Honourable Chief Justice, and I quote a little bit of what she said, Malaysian judiciary recognizes that the administration of justice cannot come to a grinding halt, and that it needs to maintain continuous access to justice. And for this reason, the Malaysian judiciary is adapting to means of keeping its processes and services running despite the pandemic. So, unquote. And so what we had to do is to confer, and we did confer with the stakeholders, including the colleagues here and this platform, or guidelines, administrative letters were issued to basically explain how we were going to do things, how we were going to manage, and where to ask or to direct your questions to. And then in the meantime, for long-term solutions, there had to be changes to the written law. So amendments to the relevant regulations and statutes were proposed and have since come to pass. Basically, all this was to prepare and to accommodate electronic and virtual hearing at all levels. Initially, before the law was amended, consent of counsel and parties was required. It no longer is. It's left to the discretion of the court. And initially, we only looked at Skype as being the preferred or the only platform. We subsequently have accommodated Zoom and anything else that's helpful. And some of my colleagues now turn to WhatsApp as well. We're not so sure about the security features there. So all in all, that's what we've prepared in place. The problem, as always, is getting everybody to that same platform. It's almost like Harry Potter's platform at 9 3/4, isn't it, at King's Cross? Getting people there and getting them to jump. So to me, I looking in preparation today's webinar found that we've responded actually quite positively to digitization. And actually, thanks to it, it's business as usual or almost as usual. We've continued to conduct case managements by way of e-review. We've heard uncontested matters by video conferencing using all these various platforms. In fact, when we heard our first appeal virtually, we live streamed it. And it was very exciting times, I think, for a lot of lawyers and public out there, because you only really go into a courtroom if you are an interested party. Otherwise, you wouldn't want to sit at the back, or you find it boring and everything else. But this time, because it's virtual, you get to see what the judges see. So you don't just see the back of the counsel's head. You see what the judges see. And I will tell you, many lessons were learned from that session. And a lot of people then appreciated how hard it is to actually conduct a hearing from any angle. We also conduct e-balloting. There's something else that we do, e-balloting, and that's for empaneling our appeal panels at the federal court. So it's not about, one person deciding, oh, I think Mary should hear or Mary shouldn't hear, but it's through an e-balloting. And the feedback from my colleagues, James, has been, as I said, very positive. The officers, the lawyers, witnesses have all worked remotely. It's intruded into our space, but there's something I think I need to share, and that is, perhaps you might not have a problem, but personally for myself and quite a few colleagues, we sometimes can get quite overwhelmed by this genius that we have created, this AI and this digitization. We sometimes are quite afraid to ask. We're actually also quite shy to ask, what is it? Why is it? And how? And what's worse is that even after it's been explained to us and shown how to do it, we still can't control it. Not like a physical courtroom where just sit down. You can't quite do it. You might be muttering and all that is caught, or you can hear counsel muttering, and you might not like to hear you might not like what you hear. But all said and done, having tried it all, we've learned huge lessons. We're tweaking from these experiences, what to do, what not to do. And the positives, pardon the pun, have actually been more encouraging than otherwise. We're not lugging back weighty trucks, loads of boxes of files anywhere, breaking our backs, etc. We've saved time, certainly costs, etc. And I must share with you an experience of a colleague, Justice Wong, who recently conducted an online trial. And he had experts from several jurisdictions. He had to make particular arrangements on time differences and also to take care of security concerns. But all of that were attended to with a lot of cooperation from counsel. And I can tell you his lordship came away a changed man. He speaks of the ease of conducting trials by this means. He encourages it. And he says that actually he felt sorry for the witness because there's just so much tension from the witness because it's all now in your face. But he has shared a lot of positives with me. And he says that, it's so encouraging to do a trial in such a safe environment without the witnesses complaining about, I'm jet lagged, I lost my passport, I missed the flight, I've been waiting, he's getting fretful. A lot of all this have become relics. So his lordship has recommended and is looking forward to more online trial hearings with witnesses. And he thinks there are no real impediments. And in fact has encouraged lawyers out there to use it. And he also thinks that there should be more extensive use of digital signatures, especially for the affirmation of affidavits, to overcome some concerns. And personally, I feel that the concerns are about connectivity, that sometimes you might have heard the story of one of our students, not a law student. She had to climb to the top of a tree in order to get some connectivity. And even then it was not consistent. I can't imagine the lawyers doing all that. Terrified if get lawyers and judges doing that as well. But connectivity and the quality of connectivity appears to be some challenge. But I think these can be overcome.
Excellent.
Shall I share with you about the intellectual
Please
property?
Just before you do, I'm going to ask the audience a question. They can vote on this live while you are sharing this story. So there are two questions here. The first is whether members of the audience, particularly in-house counsel, have had any direct experience of a remote hearing at any time. Second, of course, is whether you have had experience of one since the pandemic. So while people are voting on that, Judge, yes, please could you share the story with us?
That's a question for me?
Yes, sorry, Judge. It's a question for you to share the story with us.
Whether I've had experience with remote hearings? Yes, I have.
No. Sorry. While we're waiting for the results to come.
Oh, while waiting. All right. Yes. Well, I was going to bring some focus to the Intellectual Property Court, and this is part answer now. Another part answer to your question as to whether or not digitization has been affected, has helped, etc. The IP courts, strangely, the statistics show there's been no slowdown or reduction in volume of cases filed. And in fact, according to Justice Radzi, who helms that court, for the whole of last year, they had about 109 claims filed. But up to October of this year, with about 2 months more to go, he's already got 90 claims. So he thinks perhaps with the change of the law to come, there might be some impact, but COVID doesn't seem to have, digitization and remote hearings doesn't seem to have had any dampening effect in terms of the filing of claims. So in terms of the hearing, in the Chief Justice explanation and the press release, Her Ladyship had indicated that we still continue to have hundreds of thousands of documents being filed, and the numbers, because these statistics are up to April, but the numbers have shown that nothing really has changed. And really at the end of the day, James, is because we've had that head start since 2009. And what has changed is having hearings remotely. And because the courts are not a critical service, or essential service, so we have had to slow down in so far as the non-essential cases or the non-critical cases are concerned. But the criminal cases have gone on. The difference, of course, is recently the prisons have had some unfortunate spikes in COVID cases. So the prisoners have not been moved. So the hearings have reduced. We've stopped actually criminal hearings, criminal physical hearings, but the remands, bail applications, those matters have been carried on. Right, James, back to you.
Excellent. Can I trouble you for a rather wonderful story involving a car park briefly?
Oh God, that one. Yes, that actually was shared by Justice Radzi. Because of the remote virtual hearings, which he has been conducting for his cases, he had this most unusual experience. In the course of one hearing, His Lordship noticed the background of one of the counsel was appearing before him. So His Lordship quizzed counsel. He said, "Counsel, are you in your car?" And guess what? Counsel had to answer, yes, he was. And it seems counsel found that was the most ideal place to have his hearing. It was secured, he wouldn't be disturbed, and he had the best reception. He could drive till he could get the best reception. But I think the real reason was because he couldn't get to wherever he was supposed to be in time. He got his times wrong. But whatever it is, it actually worked. And his lordship allowed the hearing to continue with counsel in his car after being assured that the counsel was parked in a car park and he wasn't driving and he wasn't using hands-free, because that was not acceptable. Yes. So that is how far and how versatile virtual hearings can be. And I think counsel was probably using his mobile device for his hearing. He wasn't even using his laptop. So there you are. See where we've come.
Counsel to turn it into a virtue and claim that he deliberately selected his car. Very well done there. Okay, excellent. Look, thank you very much, Justice Mary Lim. I will close the poll now. I guess the second question here is the most interesting for our purposes. So 19% of the audience has had direct experience of a remote hearing since the pandemic. So perhaps those of you in the audience who have had direct experience of a remote hearing can share your thoughts or questions through the Q&A function. I will turn now to Bahari Yao of GAN Partnership to get a counsel's perspective on this. So Bahari, following on from Judge's rather wonderful introduction, what are your perspectives as counsel? I mean, do you think the digitisation of justice has impacted access to and the quality of justice in Malaysian courts? What are your thoughts?
Okay, thank you, James. How I would address this question is essentially twofold. First thing, let's look at what's happening surrounding. Now, at the guts of the fourth industrial revolution, the Malaysian has actually aimed to re-engineer the human experience by using technologies with the aim of decentralizing the authorities, de-emphasizing the divisions along the lines of colors, creed, and country. This is what the Japanese has coined as Society 5.0. Now, this concept has been adopted in Malaysia here as Malaysian 5.0. Now, when the COVID-19, as Justice Mary Lim said, nobody has anticipated the magnitude. It has actually ultimately become a tipping point for this century. Now, while the world is shifting very drastically, business are equipping themselves with advanced technologies, new business models, so that they stay relevant and competitive. So is the justice system. Now, the pandemic has really put a lot of cross-check on everyone about the progressions, globalizations, digitalizations, and the transformations. Now, how do we fare so far? Now, to answer to your question, James, I'm going to look at it from three perspectives. Whatever technologies we may have, I think it will come to a naught if the law does not support that position, and if the policy doesn't support that position. And most importantly, we are talking about justice. How does these digitalizations impact on the access to the quality and the access to and the quality of justice in Malaysia? I think it all boils down to the mindset. And in fact, the most important thing is the Malaysian judiciary mindset and how ready are the judges. So I'll address your question in these three perspectives. Now, first thing first, in terms of the statute and system, very proudly, 22nd of October 2020, that is where there was a new provision that was incorporated, Section 15A of our Court of Judicature Act, where court may, in the interest of justice, conduct proceedings, whether it's civil or criminal, through a remote communication technology, and whatever the communications, remote communication, it shall be deemed to be conducted within the local jurisdictions of the High Court. And that's where the car park story comes. You can actually have access to the justice wherever, whenever you are. And in fact, the provision goes as far as to say that place, as far as the court, it can include cyberspace, virtual place, or virtual space. Now, I have a confessions to make at this juncture. Now, I'm a dinosaur. So when this thing came about, the first thing I said, if I'm a dinosaur, the wise man and the wise lady who is sitting up there, who is, Justice Marilyn may not like to hear this, far more older than I do, if I cannot cope with that, come on, be real, they can't cope with it. And I will share with you my stories later. Some of it is quite embarrassing. So that's one aspect. We have then our Trademarks Act, which was recently came into force, and quite proudly state that the provisions there are in line with our international friends across the globe. Apart from paving ways for these accessions to Madrid Protocol, there are a lot of other provisions like the Ministry of Domestic Trades are given certain powers to prescribe regulations to enable Malaysia to fulfill the international obligations. So that is the other set of legislation. Then we have the Digital Signatures Act, the Electronic Commerce Act 2006, where the act itself has paved its way to allow documents to be signed instead of the traditional wet ink signatures, documents which will not be denied of the effect, validity, and enforceability on the ground that it is merely because it is in electronic form. So from the legislation point of view, there are statutes which paves this way, which supports our move towards a digitalization environment. I mean, although to be quite frank, these legislation doesn't mean that we can all ditch our pens and paper. We are not quite there yet. There are certain provisions like the National Land Code requires certain documentations to be still signed by wet ink. So for example, if there's a power of attorney, wills, or conveyancing transactions, those are still something which you need to sign by wet ink. But I suspect that with the advancement of technology and with this COVID-19 outbreak, and as what our Prime Minister says, we all need to have a new normal, those are going to change in no time. And yes, the legislations are there to support all this move. Now, before I talk about the judiciary points of view, perhaps let me share with you from the policy standpoint. Now, we have our national digital ID policies. One of the research that was conducted by the e-marketeers, which entitled Retail E-commerce Sales Worldwide by Region 2020, surprisingly, leading the chart, Asia Pacific is forecast to have 2,448 billions of e-commerce sales in 2020, as compared to Middle East and Africa, 41.56 billion. Now, headlines by the Philippines, Malaysia, and Spain, 9 countries are projected to see more than 20% of growth in the retail e-commerce sales this year. Now, our Ministers of Communications and Multimedia has this to say, an advanced method of authentication users' identity online, where it is the users, whether it is the user setting up accounts for the first time, logging in, the National Digital ID enables the digital service providers to make highly accurate trust decisions in real time. So even from the policy standpoint, we are moving ahead. Now, of course, all this are not going to work if judges themselves are not ready. You know, I'm not sure as a student, we will all remember when we learned our jurisprudence, one of the complaints, one of the critics people always say is judges, centuries ago, judges are from different social backgrounds, educations, upper class people. They all live in the ivory tower. But fortunately in Malaysia, I'm proud to say that judges have embraced the technology development and they are quite forefront in their mindset. They are quite on the ground and on the ball. That's where I have a confessions to make. I remember just shortly before the MCO, in one fateful morning where we all have to appear in the Palace of Justice, all counsels in our usual self, dragging bundles and bundles of authorities, since we have killed the trees, right? So we might as well just bring them along. Two wise ladies and a man came out smartly with their gadgets. They look at us as if we were the dinosaurs. And in fact, the chair of the panel on that day remarked, "Counsel, you would better catch up with us, otherwise we will not be able to follow you." So it appears that it is the reverse, that the courts have moved ahead. Now, again, whether the quality of justice, is it going to be impacted because of digitalizations? My view is it is not. In fact, judges are, in Malaysia, they do not decide things in stylo. And in fact, I'll share with you some of the cases that we have, of our Malaysian judges have came about. And it is quite clear that the mindset, they don't live in the ivory tower and decide things in the world of their own. They do have the concept of globalizations, evolutions of laws across the globe, and they're always very vigilant as to what's happening and quite aware of what's on the ground. The first set of example, at the height of the illicit trades, counterfeit products pave its way into the Malaysian water, where there's always this adverse perceptions that Malaysia becomes the hub of all this illicit trade. Justice Mary Lim said, as her leadership then was in the High Court in the case of Philip Morris Products SA, said this: the purpose of establishment of free zone is clearly for the purpose of promoting the economic life. But that does not mean that the free zone is free for all area, free of all laws, and it's a lawless zone. The enforcement agencies continue to hold jurisdictions over, and in these free zones, plaintiffs' rights in the registered trademarks are rights in rem. The second set of authorities, judges don't decide case just based on what's happening in Malaysia. Consistency of decisions made in Malaysia with the decisions made in foreign land is always an important factor. So for example, in the case of GS Yoza, Justice Wong has this to say: it is undeniable that the intellectual property rights in respect of particular products may be protected and enforced in many jurisdictions. The court should not take a blanket view regarding the protection and enforcement of IP rights. Now, if foreign courts have decided on a particular issues relating to the same trademarks, although Malaysian courts are not bound by it, it is an important factor to take into account to ensure consistency, predictability in the protections and enforcement of IP rights in various jurisdictions. In another Philip Morris case, Justice Wong said, adopting Justice Mary Lim's earlier decisions and in respect of illicit trade, to say that policies considerations to combat the illicit traits are very important. If Malaysian judges are not vigilant, we will be used as a hub for all these counterfeit products to pass through our water. And in fact, in this Philip Morris Goodness and Import and Export case, Justice Wong went further to say that in fact, the decisions of the foreign trademarks authorities concerning a particular trademark can be taken into account when the court makes its decision. Now, the third example, where how forward-thinking we are as a nation. Now, one of the particular principles that we have is trademark law is territorial in nature. Now, this concept is very much entrenched in our trademark jurisprudence. But in light of globalizations and the cross-border transactions, Justice Ramli Ali, as his lordship then was in the case of Abercrombie, says that even an internet sales, for so long as the sales are being made into Malaysia, those are recognized. Now, in the case of Walton International, the Court of Appeal says this, that there's no artificial limits on geographical areas to which reputations or goodwill can or cannot extend. So there we are, where even the judiciaries are now thinking that globalization, internet, is something which is recognized. Now, parallel import. Parallel import is always an issue. The issue whether in Malaysia and also in a lot of jurisdictions. Justice Azhar Muhammad in one of the cases, Teng Ying Heng says that although the law does not expressly forbid importations of parallel goods into Malaysia, it is lawful, but looking at our act, it is possible for the Malaysian or whoever who owns the trademarks in Malaysia to stop parallel import of the goods into the territory of Malaysia. In fact, all this more recent time where we were faced with the COVID-19, Justice Wong has a recent decisions in SS Prescott. You know, in the court, usually, you know, when the evidence is to be taken by way of affidavit evidence, it has to be a sworn affidavit. Now, Justice Wong in that case took judicial notice on MCO, CMCO in Malaysia and in other jurisdictions where affirmations of affidavit wasn't possible. But not wanting to stop or put a halt to the proceeding, Justice Wong allows the affidavit, unaffirmed no doubt, to be taken into account for the purpose of proceedings. Of course, with the undertaking that once the movement controls is lifted, the affirmed version is to be taken. Now, all in all, what I meant to say is that looking at the history, at least from the perspective of counsel, that our judges are quite forward-thinking. So even though digitalization was something which is an alien to many of us, but with the proper mindset, I have no doubt that the access and the quality of justice will remain not affected. And in fact, one thing I wanted to say is that when we're talking about the access to justice, at the start of the MCO, where all of us were not allowed to go out of the house and we all complained, and then when the court and the people talk about virtual hearing, as I said just now, first thing they said it is impossible. But now more and more cases are being conducted through online, whether you're in a car park, whether in your dining table or in your cozy office. you get access to justice. And in fact, the million-dollar question is that if this is going to be uplifted, are we going to go back to our old lifestyle, or would these be a better thing to do? You know, Malaysia, no doubt that we are a small nation, but we do have very big courthouse. So imagine, you know, especially in the High Court, in fact, in the Palace of Justice, the court is huge. So if one day you have two cases, you know, to run from one wing to another wing, it does take a lot of effort. So now everything that is conducted online, you just sit at where you are, whatever your grievances, whatever your complaints are essentially heard like this. So I think all in all, my conclusion to this aspect is that while everybody complains about COVID-19, me alike, but it does change our life. It does force the judiciary to rethink, to realign, to embrace the technology, and to move forward.
Excellent. Look, thank you very much. And I can see that we have now been joined by Annette Magnuson of the Arbitration Institute of the Stockholm Chamber of Commerce and Kevin Nash of the Singapore Arbitration Centre, both of whom I introduced earlier. Welcome to you both. We will get your perspectives in just a second. I can see also that we have questions from the audience. But look, Bahari, in the interest of time, I will skip further questioning and move on to our next section. So before we hear from Annette and Kevin, I will turn to Ms. Ilya Hashim of the Intellectual Property Office. Ilya, welcome. Look, I'm going to just open the floor to you to say some words about, I guess, some of the issues facing the IPO there in Malaysia. Please.
Right. Thank you, Mr. James. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and a very good evening, good morning to people in London and wherever you are. Justice Datuk Mary Lim Tiam Swan, Judge of the Federal Court of Malaysia, Mr. Bahari Yao, and Mr. Fu Jun Liang from Garden Partners, Ms. Annette Magnuson, Mr. Kevin Nash, and of course to all of you who are here today, my fellow bosses, if they are around. Datuk Mary Lim, my fellow speakers, and ladies and gentlemen, on behalf of MIPO, I will speak in three parts today on how MIPO faced the challenges during this trying time, which are: one, coping at the start of COVID-19 and navigating government directives; two, how COVID-19 impacts the value of IP; and I'll end my presentation with timely changes to the system and future changes to expect. Before I do that, thank you, Legal 500. I'm supposed to thank you to give us the opportunity to be here today and share our experience with all of you who are here today with us. Before I start talking about MIPO's strategy and initiatives in coping with the pandemic, allow me to lay down some background on the government's directives in dealing with the COVID-19 pandemic in Malaysia. Malaysia announced the very first movement control order to be effective on 18 March 2020, where all offices and business activities are shut down and closed. As such, all government offices and business premises were closed, including us at MIPO. Irrespective of that, the business premises were closed. Our business operation continued online, where all the employees of MIPO began working from home. Although we at MIPO are very familiar with the concept of working from home, as the initiative was already introduced by our previous Director General, Datuk Azizan Muhammad Sidin, sometime in 2014, the working from home initiative was introduced then only to our patent examiners and trademarks examiners. These examiners then were given a higher KPI, key performance index, if you like, set for them, where they will have to produce 30% more examination results as opposed to the examiners and of trademarks and patents working from the office. However, today, working from home and online communications has become a new norm for all employees in MIPO, including myself, from the legal division as well as our finance division. So, as Justice Datuk Mary Lim earlier has mentioned, that our movement control order has been done in three stages, from MCO to CMCO and RMCO, and now we are back to CMCO. We are keeping our activities in business premises at a minimum number. Following this very recent order, my post staff have been working from home, and only 30% of the staff are working from the office. If I can share with all of you, almost 100% of our trademarks and patent examiners are working from home, and they are expected to produce 20% more examination results whilst working from home. From all these phases, we at MIPO have certainly learned from one phase to another and come up with several steps to cope with the situation. As I mentioned earlier, during the MCO period, all the officers work from home, and everybody, the registrar, fellow assistant registrars, work, and including the support team like IT, and we work remotely at the comfort of our home. And however, online search and filing are made available through our online systems, and communications between public and internal communications are done via telephone and email. To those who are affected by periods for office actions, we do give them extended periods for such as for priority date claims, renewals, and responses to all the office actions. And all hearing sessions fixed, especially for trademarks applications, they were postponed. And following that, after learning from the first phase, we move on to the second phase of CMCO, where now the management has introduced a combination of rotation system for the staff. Some of us work at the office and some of us work from home. However, likewise, online search and filing are still made available online. Customer service counters are then open for a limited time from 9 a.m. to 1 p.m. from Monday to Friday. Extended period for priority date claim, renewals, and responses to some office actions are still continuously given. Training and awareness programs are conducted via webinar, and meetings internally are conducted virtually. Finally, we went on to the recovery movement control order. The combination of work among the staffs, rotation systems, and working from home are still continuously taking place. However, our office is open as usual. Customer service counters has no more time limitation. We are working as usual. From all these efforts, we believe that they have resulted in positive outcome, where statistics have shown increasing numbers from all fronts, especially there are increasing numbers of applications being filed in Malaysia. Applications of trademarks being registered has increased as well, and applications of patents are being granted by the examiners working from home. For instance, if I may share with you the statistics that we do have for trademarks, for the period from the period of June and October 2020, there are 20,183 applications being filed in Malaysia, as opposed to only 19,874 applications were filed in between June to October in 2019. So there are increase in number. So I suppose that's a very good sign that applications are coming in and nobody is slowing down on that front. Working from home has also resulted positively in patents being granted, where 1,129 patents are being granted in October 2020 itself, as opposed to 637 only in October 2019. So I suppose our examiners are working hard as well to keep up with the KPIs. Likewise, for trademarks, examiners have registered 3,400 trademarks applications in October 2020, as opposed to 1,483 applications being registered in October 2019. So that's a great spike. Okay, in order to accommodate to all these operational activities, several administrative instructions through registrar's notices have been issued. Among the content of the notices are, among others, on remedies and extension of time limits available for applicants and registered proprietors of trademarks, patents, ID, GI, and copyright. Mode and manner of filing new application, including the application which involve priority date claim under Article 4 of the Paris Convention, as well as renewal of registration of trademarks, patents, industrial designs, and geographical indications. So in view as well of the recent introduction of the new Trademarks Act 2019, which was recently being enforced in Malaysia. The Registrar of Trademark now has the power to issue registrar's guidelines or practice direction with the force of law behind it. Through this, we have introduced another manner of filing and payment of prescribed fee to accommodate to the current situation, as to keep the minimum number of people in MyPo. So according to Practice Direction number 2, 2020, selected applications or form may be filed with the registrar by emailing the same to the registrar together with the proof of payment of the prescribed fee made through interbank online banking. So I suppose we believe that by providing this avenue, it will lessen the number of applicants or registered proprietor or even their agents to be physically present in MyPo to do their filings. As I am talking on an international online forum whereby there might be some foreign applicants, registered proprietors or agents listening in, irrespective of the manner that I've mentioned that was made easier, I'm afraid that all international applicants, registered proprietors or agents might still need to appoint the local agent to represent all of you before us, either the Registrar of Trademarks, Patents, ID or GI. But rest assured, we are doing our level best to accommodate to the needs and welfare of our registered agents in accommodating to their clients' needs. Speaking of registered agents, it is also our pleasure to share with all of you our success in conducting a webinar last July 2020, which was a preparatory course for candidates who wish to seek for Trademarks Agents examination, which is a new requirement under Trademarks Act 2019. Following the course, a formal examination was also conducted online 2 weeks after the course. Out of 30 candidates who sat for the examination, 25 candidates passed the examination with flying colors. Okay, based on all that I've shared earlier, I may sum up that to answer the second issue for the day, that as the operations of MyPo is as usual, we believe that it does not negatively affect the value of IP in terms of getting them filed in Malaysia, to claim the first right to file and ensuring the mark is being managed, the mark or any other IP is being managed and maintained. What appears to be different now is that for trademarks, in addition to manual and online filing that was already made available earlier prior to COVID-19, filing selected forms can be made via email to the Registrar of Trademarks. Issuance of decisions or any office actions will be made via online system and by post, which would reach the address for service which are in the Register of Trademarks. For other branches of IP, like patents and industrial designs, any filing of applications and other forms can be made via our online system. So however, if you are interested to file any forms under the Copyright Act, you may do so by dropping the forms at our counter in MyPo and together with the payment via check, bank draft, or proof of EFT payment. Should there still be any other issues, our officer in charge for help desk are always available to give assistance required from 8:30 a.m. to 5:30 p.m. And in addition to that, we are also available on social media, either on Facebook, Instagram, Twitter, where you can reach us directly. So if you prefer a more traditional way of reaching us, we are also available on WhatsApp call. It's called IP Friends, and our email address, ipmalaysia@mypo.gov.my, is always there for anyone to reach us. Okay, allow me to continue to the final part of my presentation today on the timely changes to the system and future changes to expect. As I mentioned earlier, recently in 2019, the Parliament has passed a new law, namely the Trademarks Act 2019, replacing the old Trademarks Act 1976, which has now been repealed. Through the introduction of this new act, trademarks protection for traditional trademarks such as device, brand, name, signature has now been expanded to cover non-traditional marks such as shape of goods or their packaging, color, sound, scent, hologram, positioning, sequence of motions, and any combination else. Non-traditional mark is now able to be registered in Malaysia. So to all, if I may do some advertisement to all entrepreneurs listening in today, you may want to consider getting your traditional or non-traditional mark registered in Malaysia. And if you're from abroad, Mr. Bahari is one of our prominent registered trademark agent in Malaysia who may be able to represent you before us. In addition to the expansion of protection in Malaysia, Thanks to all the hardworking and dedicated officers and Ministry of Domestic Trade and Consumer Affairs, as well as the parliamentary draftsmen in the drafting division in Attorneys General's chambers, and not forgetting the Trademarks Law Review Committee members in MIPO, the new Trademarks Act 2019 also allows Madrid Protocol to be enforced in Malaysia. After Malaysia's accession to Madrid Protocol in September 2019 and the Trademarks Act became enforced in Malaysia on 27 December 2019, international registration holders may then begin designating Malaysia as one of the designating countries for them to get protection. At the same time, fellow Malaysians who wish to expand their territory of protection may use Malaysia as the office of origin to get protection in any of 123 countries which are the members of Madrid Protocol without the hassle of filing applications directly in those countries through the national route. Therefore, following the introduction of this new act, it is timely enough to accommodate to the changing situation in Malaysia, whereby foreign applications or foreign applicants now have the option either to directly designate Malaysia from the comfort of their own home or their home country, or filing through our registered agents through the national filing route. So all of this can be done online. So as we may very well know that upon becoming the 106th member of the Madrid Protocol, Malaysia now has two duties to be carried out. One as the Office of Origin and Designating Contracting Party. So even when we receive international application, or better known as MM2, from fellow Malaysians who wish to get protection in any 122 countries, which are members to the Madrid Union, and upon certification, the Registrar of Trademark will then submit the certified international application to WIPO, World Intellectual Property Organization, through an online system called Madrid Official Portal for their onwards action. Likewise, there is a dedicated online connection between WIPO and MIPO being set up for MIPO to receive any designations from holders from other 123 countries to get their trademark protection in Malaysia. Upon receiving the designation, trademark officers may then be able to access to the international registrations and begin with their formality or substantive examination. On that note, I wish to sum up that despite the circumstances relating to the pandemic, the value of trademark remains as it is and may not be negatively impacted. Okay, I'm already coming to the end of my presentation. If I can reiterate what I have mentioned earlier, that MIPO is continuing our operations as usual, with some modifications, of course, as mentioned earlier, to ensure that the government's directives to combat the spread of COVID-19 is complied with. We are all committed in ensuring that all transitional issues experienced by the applicants, registered proprietors, or the registered agents, as well as any other stakeholders impacted by our decisions in our processes, are kept to a minimum, despite these difficult circumstances. Other than that, should there still be issues, as I mentioned earlier, our officers in charge are always available to give any assistance required. Yeah. On that note, we will also keep everything updated on our website. So every notices, practice directions, latest information at all, anything at all will be posted on there for public to refer to. Finally, I also wish, on a personal note, I also wish to share that I'm very delighted to hear what was shared by Justice Mary Lim just now on how the court has embarked on online hearing. I will certainly pass this message to our management on how things are done in court in conducting the online hearing. We will positively learn from this and also other IP officers in conducting online hearing in view of introducing the same in our office. With that, I end my presentation. Thank you.
Thank you very much, Ilya. I will move on now, in the interest of time, to our third section, looking at arbitration and court proceedings. So we've heard from the Malaysian courts, we've heard from the IP courts. Let me now turn, I guess, Jun Liang, I will come to you right at the end, but I suppose first, if I may, I will turn to Annette and Kevin. So just to reintroduce them for those of you who joined late, we have Annette Magnussen, who is Secretary General of the Arbitration Institute of the Stockholm Chamber of Commerce, the STC, one of the preeminent global centres of arbitration. I'm sure you all know it, and indeed many of you will know Annette. We also have Kevin Nash, who is Deputy Registrar and Centre Director of the Singapore International Arbitration Centre, SIAC. I'm sure in this region in particular, many of you know Kevin. Annette, I will come to you first. So look, the SCC has been an early mover, really, when it comes to remote hearings. I know you've implemented a lot of changes in preparation for this, but can you perhaps start by giving us a sense of how the pandemic impacted you in Stockholm? I mean, you were prepared for this, but nonetheless, it's been a change. What has your experience been?
So thank you very much, and thank you for the invitation to be here and to meet everyone, and good morning and good afternoon and good evening wherever you are in the world. You're right, the pandemic has affected all of us, and but in different ways. And just as a brief background for those who might not be very familiar with the SCC here in Stockholm, so we are an international arbitral institution, and we do about 200 cases per year with parties from 40 different jurisdictions or so on an annual basis. So it's a very sort of a global operation. We do primarily commercial arbitration, but do also a fair number of investment arbitration. We see a lot of IP disputes in addition to general commercial disputes, and a lot of energy cases here in Stockholm. So the way the pandemic affected us primarily was the same as for many people across the globe. We had to sort of move home, and that happened very quickly. And again, not a unique experience for us here in Stockholm. In this sort of environment, the challenges, of course, were many. First and foremost, to make sure that we safeguard the operations and the safety of our health of our members of the staff, and make sure that our cases kept moving. So this was these were issues we had to deal with, and I do think in this shift, it was very important for us to have a very open communication with everyone involved. So open communication with the tribunals, open communication with the parties, and all the stakeholders out there, and also, of course, a very strong collaboration with our other arbitral institutions. And I was very struck to hear Justice Mary Lim talk about the generous exchange of know-how, because this is something that I can really confirm that this is sort of the experience from the international arbitration community as well. I do think that in all the terrible things that we have seen in the wake of the pandemic, we have also seen this camaraderie, collaboration, and everyone really being very creative in moving things forward and having this sort of bigger picture before us, that we need to have the wheels keep turning, and we need to do that with integrity. We need to do that, again, keeping in mind the health and the safety of everyone around us, and including people working for us. But there was this ambition to do whatever we can to help each other and to exchange experiences. So this is also something that was very important in Stockholm this spring, and continues to be important. And one of the initiatives you might have seen was that a number of institutions came together and signed this joint statement from the institutions. SIEC was one of them, obviously, and there were I think there were in total 13 institutions originally. But then after the first original statement was published, a number of other institutions said, we support this, we confirm these principles. And really what we tried to say with this statement was that we understand your challenges, we are here for you. There are tools available out there. There are online options for your in-person hearings, for example, and use the rules of the respective institutions and the tools that they provide to be flexible and to navigate these new challenges and to move the cases forward. Because we did see a number of institutions, there were tendencies of using the pandemic as an excuse to stop everything, which was not acceptable from our end. You can use what's out there to move the cases forward. So that was really reassuring that the institutions were able to work with that. So that the collaboration is really something, very, very strong takeaway from this entire experience, and continues to be. And you were mentioning in Stockholm the work that we have done with the sort of the SCC platform. which is a case management system which was introduced in September last year for all our tribunals and parties to collaborate in the cases. So this is something we have been talking about for many years, and we were very happy last year in September when we were able to introduce it.
And is this the ad hoc arbitration platform?
So the ad hoc arbitration platform is on the same technique.
Okay,
it's the same platform.
Right.
So the SSC platform was first introduced for all the SSC cases. So really what it is planning the case, secure communication, storage of files. This is sort of, you get an overview of the proceedings, you upload your briefs on the platform rather than sending them by email or DHL boxes or whatever. So this is like a one-stop shop for all the parties and the tribunals involved in the SSC cases. Now, the platform was introduced in September last year, like I said, and from the very beginning, we got a lot of questions. So could I use this in other cases, or could I use this in some ad hoc cases? And we put that sort of on the back burner for a while, as we were introducing the SSC platform to the SSC cases, and just got everyone used to it. But then as the pandemic struck, and this I think is very telling for how a lot of projects went really fast forward in March and April because of, we had to, digital projects that in a normal environment would have taken maybe a year or even longer to just launch. Now it happened in a matter of weeks or months. And the ad hoc platform, I think, is a good example of that. So we got these questions because of the pandemic. What can we do using the technique of the SSC platform for other cases as well, ad hoc cases? So with the collaboration of the providers of the SSC platform, with the technique for the SSC platform, we were able to launch the ad hoc platform. So it's the same technique, it's the same service, but it's separate from the SSC platform, obviously, and it's only for ad hoc cases. And this is a collaboration that we are being able to offer without any charge, because of the collaboration with the provider of the platform itself, trying to do what we can to keep the wheels turning in international arbitration cases during the pandemic. So that has worked really well too. I think since the pandemic started, a number of additional institutions have signed on to similar models, or the same model or the same technique, the same platform the SSC platform is built on. So I think there is a very, very, very strong resilience in our community. And also what we have learned is that there is a great openness to adopting new procedures. And I think all the other speakers have alluded to that there is, I mean, in our community for sure, sometimes you would say, well, it's very old fashioned, it's very conservative. And, you have all these old men and they are not open to anything new or whatever. But what we have learned is that, well, this openness, this flexibility, this willingness to adapt and really take on board new techniques, it's there. People are shifting very, very quickly. And I think that it's really a sign of strength globally that we are able to do this. And I do think what is helpful is that we all have the same goal in mind. We want to make sure that access to justice is not denied. We want to make sure the economies can still work. From our perspective, it's about making sure that international arbitration can still be that oil in the machinery for international trade and economic development. So, we have that bigger picture in mind, and that helps all of us to work together.
Okay, excellent. Can I just ask a point of clarification there? So you said that other institutions have signed on to this SCC platform. So a case doesn't need to be heard by the SCC or fall under the SCC for this platform to be used. And are you licensing this out to other centres?
So to clarify, the SSC platform is unique for the SSC cases, but it's an off-the-shelf technique that we have, that we are cooperating with an external provider of the technique behind the platform. Now, this provider and this technique is now also being adopted by a number of other institutions out there. So they will have their own platforms, so to speak. Yeah, exactly.
It's not the exact same. Okay, excellent. Great, thank you very much. I'll bring Kevin in here now. I've been waiting patiently. Hello, Kevin. I'm going to ask you for your perspectives as a representative of SIAC then. I mean, does your experience mesh with what Annette has said? What have you been seeing over the last few months in Singapore?
It certainly does. And not only have all of the institutions and arbitration as a practice really work together, I think it also shows that there are a lot of different ways to resolve your dispute. So whether it's arbitration, mediation, litigation, what everyone is working together for is being able to provide justice during these troubling times. From an arbitration standpoint and a Singapore standpoint, this is actually kind of reminiscent of the 2009 global financial crisis. If you look at how SIIC's caseload increased from 2009 onwards, that's when SIIC really moved from a regional institution to a truly global institution. We have never been busier than we have this year. We had a record year last year with almost 500 cases. It's going to far exceed that this year. It's really coming from three types of cases. Obviously, the average time from the contracting stage to the dispute is around 3 or 4 years. So the one type of case is cases that were already in the pipeline, perhaps then prompted by the COVID-19 pandemic, then results in these cases coming to arbitration. You have cases that directly as a result of the pandemic, now there's a dispute. So non-payment, non-performance on a contract. And now we're actually seeing disputes during the course of the pandemic. So we're seeing disputes and arbitrations where there's a contract that's been signed, say in July or August, and is already coming to arbitration on the basis of non-performance. So what really happened to arbitration, litigation, mediation, adjudication, as the case may be, is that we had to figure out how to handle this during the course of the pandemic. One thing that arbitration is very lucky about is that we've been preparing for this for a long time. Arbitration was already going paperless. Every institution has an automated case management system that allows employees to work from home. Virtual hearings were already happening, not always entirely virtual. So usually it would be an expert witness or a fact witness would be participating remotely. Now we have a mix of them as things are opening back up in Singapore. We have some mixed hearings where you might have sets of counsel that are at Maxwell Chambers in Singapore, other people participating virtually, or an entirely virtual hearing. So at the beginning, I think that there was some caution about virtual hearings. Are we going to be able to get our due process? Will we have the opportunity to be heard in a virtual hearing, particularly in cases where, say, witness credibility is at issue? You would hear counsel saying, no, I need to be in the room. I need to feel the room. I need to see the whites of the witness's eyes. And it was thought that it was only going to be the smaller disputes that would go to virtual hearings, not say the 5 billion USD disputes. What we're finding at SIIC is that most of these are going to virtual hearings. Yes, some are being postponed because the parties have agreed on a physical hearing. And you're hearing from tribunal members who will need to have, I think, at least 3 screens, sometimes 4 screens during the course of a virtual hearing. But there are micro expressions that you might be able to see on a witness. It's making a bigger tent for both arbitrators and arbitration counsel. There was never a better time to be able to go to an arbitration in Kuala Lumpur, Stockholm, or Singapore than now, because you can participate from anywhere in the world. It's really just time zones. And because of the time zones, we're seeing the parties are starting to streamline their submissions to a different degree. You can't go for 8 or 10 hours in the same way like you can with a physical hearing. So you're seeing sometimes more days of hearings, but shorter timeframes during the hearing days, but overall a streamlining effect. So this is a very good thing for arbitration. We do have to be a bit cognizant of any mandatory laws in the jurisdictions. Look at the language of the rules. SIIC is advantaged to a certain degree. The tribunal has very broad power to run the arbitration proceedings. The tribunal is the master of the arbitral proceedings. We specifically reference virtual hearings in our emergency arbitration provisions. And SIIC, AIC, SEC, if you look at some of the procedures that have become very commonplace in arbitration, so emergency arbitrator, expedited procedure, early dismissal, all of these procedures are perfectly suited for getting quick justice during the course of the pandemic. One thing that always strikes me is that we have all of these advancements, and some of these advancements have been catalyzed by the COVID-19 pandemic, but ultimately the advancements are going back and trying to get us back to the core tenets of arbitration, that it is supposed to be fast, it is supposed to be cost effective, limited avenues of appeal, choose your decider, confidential, all of these things. So we're using these virtual hearings to get back to where we want to be, in addition to reducing our carbon footprint. So I think it has been a great thing for arbitration during the course of a real global challenge and tragedy. And I think from a thought leadership standpoint and really building the practice, what has been very good is events such as these, because you can have people participating from all over the world, and now people are able to learn and grow together in arbitration, and you no longer have the tyranny of geography. And we're seeing at our events, and we've had, I think, more than 50 in the last 6 months, that we now have participants from all around the world rather than just, say, from ASEAN.
Okay, excellent, great. Look, it'd be interesting to get the thoughts of Justice Mary Lim and others on these topics in just a second. Before I do that, I want to turn to Jun Liang and get his thoughts on this. So are you there, Mr. Fu? Are you there?
Yes, I am.
Hi there. Could you give us your thoughts then on the lessons learned over the past few months, how disputes, I suppose, how various different centres for institutions can future-proof themselves in light of these ongoing changes, and I guess indeed whether the law is ready for these changes?
Right. Now, as Kevin mentioned a moment ago, the use of virtual hearings is not a new thing. It's been ongoing in arbitrations, international arbitrations, for a while, for a good reason. As you heard from Justice Mary Lim right at the onset, the courts have moved towards digitization since 2009. Facilities have all been there. We just needed a catalyst to use those facilities and move ourselves away from the resistance to change. And that catalyst, for good or for bad, came in the form of the COVID lockdown. That really forced us, in courts at least, to move into virtual hearings. And when the focus came on to virtual hearings, I think people who have tried it have mostly said it works. They've seen the benefits that they've not seen in the past. And with that, even in arbitrations that could have gone on physically, because we are a block from each other, we have gone on virtually as well, simply because of this entire hype about virtual hearings. And just an anecdote before I start, I was speaking to a very senior criminal lawyer just before the session today. He was in the Court of Appeal, or rather he was virtually in the Court of Appeal. He had an appeal which, like what Justice Mary Lim said earlier, he was a little bit terrified about proceeding virtually, concerned about how things would pan out. But after after the hearing, obviously having been successful in his hearing, he found that virtual hearings actually work. And he's given me some of his pointers, which I will go through some of his experiences as well. But from those experiences, what do we learn? Firstly, of course, there's the issue of the infrastructure. As we say, it's mostly there. The resistance to change when we are in court or even in arbitrations, when we propose virtual hearings, the resistance usually comes in the form of concerns about connectivity. If you look at reported decisions around the world, I think UK and Australia were the first to report decisions on arguments whether cases are to go on virtually on the onset of the COVID pandemic. And you'll see a pattern where the courts recognize connectivity problems. Everywhere in the world, there are places with in the central region where connectivity is good. There are areas where you don't have proper connectivity. So it's easy to then say, look, it's not going to be a level playing field. If you're out of the central region, you won't have that facility. And therefore, it's better having a physical hearing. But let me ask you this, is it easier traveling from somewhere with no connectivity to somewhere with connectivity? Or is it easier traveling all the way to the courts? Because that court could be across a border. Surely it's easier getting to yourself to a place with connectivity. Or I think even in one of those cases, the courts recognized that one of the key witnesses did not have proper connectivity where she was, but she could easily be provided internet dongle from her lawyers. Or in another matter, the courts said that, look, travel to a lawyer's office in a local lawyer's office, they should have connectivity. So really, there is no reason why we should today, in this day and age, be concerned about connectivity. But that's That's one thing we need to keep our eye on moving forward, because wherever we are, there is connectivity. Question is whether it's stable enough for a 3-hour hearing. We've been online for close to 2 hours now, and we've got to be sure that connectivity is uninterrupted. Right. The other infrastructure need that seems quite necessary is the need for support officers. In the example that I gave earlier, where the courts said that, look, if you don't have connectivity where you are, go to a law firm. I would assume that most law firms, wherever you are in the country, will have some form of connectivity. Now, building upon that, moving forward, if we are going to be serious about virtual hearings, it would help, particularly in the international context, to have a global network of officers, people we are in connection with, firms we are in connection with, for instance, as law firms, so that if I've got a witness in Stockholm, for example, I've got an associate firm or a firm that I regularly work with, and I can get the witness to sit in that firm with proper facilities. Not only that, if there is any concerns that the witness will be coached, there is a local solicitor who can independently then verify that the witness is sitting in an empty room, he doesn't have access to any devices, there is no one prompting him. So this international network of officers would help, particularly where you've got a cross-border dispute. Needless to say, the software and the hardware, I wouldn't get into that. I think if you're tuned in today, you have the software, you have the hardware. But the point that I will simply make is you need to be mindful of the technology out there, and be quick to pick up on technology, because you need to be on a level playing field. The larger firms constantly have got their eye on developments in technology, not only to make it easier for themselves, but to make it a better experience for the judges, the recipients, or the consumers of your submissions. That's ultimately who you're selling it to. They've got to find it easy. And on that score, you need IT support. You can't underrate that, because what can go wrong will go wrong. You will get a power cut in the middle of a session, so you need the backup facilities. So that's the infrastructure. But speaking from the context of the perspective of counsel, it's not the same as standing up in court. Now, for me, speaking personally, the focus when you stand up and when you're robed in open court is completely different, the entire atmosphere. So it forces you to be on your toes and forces you to pay attention and listen. Not the same when you're seated in the comfort of your own office or your living room looking at a screen. Now that said, the first point, we can't get too comfortable. We've got to constantly pay attention. We've obviously got to be properly attired, because technically we are in court. But the main thing that comes out of it, from my experience, and I'm hoping to practice that now as I speak, is recognizing screen fatigue. Now, I'm coming on the screen an hour and a half after the commencement of this conference. I recognize that of 110 people or so that we had signed on, we are now down to 79 people. And these 79 people, apart from people sitting in my office, are obviously going to be very tired. And I can tell you from experience, and I've heard it from judges as well, it is very, very tiring looking at the screen. And it's also very tiring speaking to the screen, because you are seated in one spot. You can't shuffle on your feet, and you've got to maintain eye contact. And the fear for us as counsel is that the judges see exactly what is going on. Our facial expression cannot be hidden. If they don't see it now, they can play it back later on the recording and they will see it. So if a difficult question comes my way and I don't hide my expression well enough, I would have given away my case. So being prepared is one thing, but being concise is the main thing. That brings me to the next point: brevity, balancing brevity and content. In the Malaysian context, whether it's an arbitration, whether it's in court, we usually put in written submissions in advance of oral hearing. Some of us, sometimes due to time constraints, do not pay too much attention to the written submissions because we think to ourselves that, look, I can deal with it when I'm on my feet. I can see what the concerns of the judges are or the tribunal is, and I can address it when I'm on my feet. That may not, that opportunity may not present itself simply because you don't have very much time. Now, in the experiences that I've had in court hearings, virtual court hearings, we are allotted a slot, and most of the time is observed. As commencement starting time is observed, so is the ending time. And if you take a little bit too long, you will hear this phrase: "We've read your written submissions. If it's there, do not repeat yourself." So we've got to be sure as counsel that our written submissions match the story that we want to tell. Then when we get on our feet, we can no longer take the position that, look, I will deal with this point, and depending on the feedback of the panel, how they react, how attracted they are to that argument, I will carry on, because we may not get that attention span. As interested as they are, they will get tired, and that's a fact. That's something we've got to realize. So the best argument, if I leave it to the end, and if I left what I want to say to 7 o'clock, most of you will not be there. Whoever is there would have switched off. So next point that comes out of it that we've got to adapt as counsel is the use of technology. Now, all of you who are familiar with the online platforms, Zoom, Teams, you'll be familiar with the screen sharing function. Now, in court, I can't hold up a piece of paper and draw a chart to put parties where they are, to illustrate the relationship between parties. But on the screen, I can, and it will be as visible to me as it is to the judges. So that is a function, and that is one example of technology that we've got to recognize is present. And it's something that we may be able to use for the purposes of illustrating the submissions quicker, in lesser words. And if it's printed, it's put up on the screen, it's something that can constantly be referred to. So that's using technology. The next point that I'll make is somewhat a contradiction. Do not overuse technology. Now, if I have something posted on my screen and I start scribbling on it, or I scroll too quickly, you have been on the receiving end, I'm sure, particularly where one of your juniors is scrolling something on the screen in front of you, you're trying to read, it gets really, really irritating. And even if I'm the most patient person, the best thing that can happen out of it is I don't follow what's happening. So that's another thing we've got to be mindful about. So taking all the experiences together, as much as we say that oral advocacy doesn't change just because we are sitting in front of the screen, we've got to recognize that our screen time, the ability to put across a message, and the gestures like hand movements, we've got to recognize that these are going to make a difference. In open court or in arbitration, when I'm sitting across the table, this doesn't make much of a difference to the judge because, or the arbitrator, because they're listening. But now if I'm illustrating in this way, 3/4 of my screen or 2/3 of my screen is going to be taken up by my hand movements. And if the judge is looking at me, focus is not going to be on the constant object, which is me speaking. It's going to be on the hands moving. And the point that we are always told to say when we advocate or when we teach online advocacy is this: drinking in a virtual setting is no different from drinking in front of the arbitrator or the judge in open court. So that's something we need to avoid. Now, aside from advocacy, I've spoken about setting up a global network, and that's something very real. Just after the MCO was lifted, we were setting up the office to facilitate a trial in New Zealand. So witnesses were due to come in, but the solicitors in New Zealand were very concerned about connectivity, about our ability to accommodate the witnesses, put them in holding rooms and so on. So that's an indication of the facilities that are required if you are going to tap on resources abroad, if you're going to have witnesses abroad. or even if you're going to have experts from abroad. These are facilities that you need to have a global network of firms that you can use, and the facilities which you can tap on. The last point I have as a requirement to adapt is the need for virtual hearing protocols. Now, if you look around, most arbitration institutes will have their own set of virtual hearing protocols. The one that's often referred to is the Seoul Protocol in the Korean Commercial Arbitration Board. You have the CIARP guidelines for virtual hearings. You have the ICC guidelines, and in America, you have the American Arbitration Association's note on remote dispute resolution proceedings. Now, these are guidelines, no doubt, but in most of them, they also set out the minimum requirements for a virtual hearing. The Seoul Protocol, I recall, I think, has an annexure that sets out what are the technical requirements. That's useful to put parties on a level playing field. Because if I'm new with virtual hearings and I'm up against a large institution which has all the resources of large firms, I will not know what is required to enable me to enter a virtual setting, to have an uninterrupted and seamless experience putting forward my argument. But if I can have reference to that protocol, technical requirements of that protocol, I will know at least what I need to put in place in advance of that hearing. Now, that protocol also puts in place day-to-day simple things that we ought to know. For example, who speaks when? Do not interrupt. Put up your hands or signal by an electronic gesture when you have something to say. No need to interrupt. There is no need, for example, if you need to take an objection when certain evidence is led, no need to raise it contemporaneously. You are not deemed to have waived your objections. So protocols of that nature will also allow parties to run the hearing in a more seamless way. The protocols will also deal with unauthorized recordings, because in arbitrations, whether domestic or international, one of the benefits would be the confidentiality of it all. Now, if I record the proceedings in the arbitration, and that arbitration concerns or involves evidence on trade secrets, for example, what's to stop that recording from being sold or handed on to a competitor? So those protocols or arrangements of that nature will have got to be considered when one works or one deals with a virtual hearing setup. So in a typical scenario, the arbitration center will host the appointing authority will host the hearing, and if they're hosting it and it's on their platform, they are the only ones who can record it. And so there must be some agreement signed with the Arbitration Institute, because they are not a party to your arbitration agreement. You can't enforce a contractual right of or contractual obligation of confidentiality against the arbitration institution. So these things need to be borne in mind. Now, the key takeaways then, as I've said, and as I think Kevin has also said earlier, with virtual hearings, really, the world becomes borderless. We can tap on resources from abroad. And so some of us may then have the concern that with foreign expertise coming in, we lose our market share, right? And even in Malaysia, we've got East Malaysia, West Malaysia, and there's that concern that we can't practice in courts in East Malaysia. Likewise, they can't practice in our courts in West Malaysia. And one of the basis of their concern is that, look, we will intrude into somebody else's market. And that may be the concern when the borders open up through virtual hearings. But the way I look at it is that in itself is a catalyst for ourselves, for us to improve ourselves, for us to upskill, to become competitive, to match what foreign expertise there are out there. The benefit that comes out of it then also is this. When it becomes borderless, our services are similarly available overseas. All right. Obviously, we can't appear in courts overseas, but in the context of arbitrations, we can appear anywhere. And us being in Commonwealth jurisdiction, a lot of Commonwealth jurisdictions out there have largely similar structures in terms of their legal systems, in terms of their laws. So it makes us marketable in that way. And in the line of work that I do as well in construction dispute resolution, you've got experts constantly coming from abroad. Kevin has mentioned briefly how virtual hearings will allow cost saving. It becomes more efficient, but it also allows us today to tap onto expert evidence from abroad when it wasn't available yesterday at a physical hearing. And I'll give you a good illustration of this. This was in the context of a court matter where we had an English expert who had to fly in on the first occasion only to find out that there wasn't sufficient time for him to take the stand. Now, it's 13 hours one way on the flight for him, another 13 hours back, business class, charging time cost while sitting on the plane. And you leave aside his board and lodging here. Now, the 13 hours time cost that is spent on the plane, which obviously is painful to the client, is the same time, it's largely the same time for the witness to spend 2 days in court, right? Two working days in court will hardly make up 13 hours. And so the same amount of money I spent paying the expert to travel 13 hours one way, 26 hours two ways, I can virtually keep him in court for 1 week on his time cost without all the attendant costs of a physical hearing. So it makes accessibility to foreign expertise so much better. So with that, I say the consequences are great. It's beneficial everywhere around the world, whether you're exporting or importing foreign talent. And from the Malaysian standpoint, purely, we've got the advantage of common law knowledge. Insofar as arbitration is concerned, the structure of our arbitration laws largely follow the model law as in most countries. English language being our operative language in most arbitrations. Cost, sadly for us, our currency isn't doing too well, but it means that to the rest of the world, we are cheaper. And that's a benefit that I see. Lastly, of course, being able to last till 6:30, we are quite a resilient bunch as well. So it puts us in a good place. Moving forward, what is required, I think, in a virtual hearing setup from a practical standpoint is the need, whether in arbitration or in court, for agreed facts. The more agreed facts you have, the less the need for a detailed cross-examination of witnesses. Now, the rule in Brown and Dunn, the need to cross-examine witnesses and so on, those are matters that are largely no longer prevalent in international arbitrations. It is largely documents-based. Now, if you've got a very good reason why you're departing from a story that is told by a document, it's already got to appear in your pleadings. So the need to have the witness on the stand, to cross-examine, to observe his demeanor, I personally think that it may be overplayed. It may well be an excuse by certain quarters to avoid physical hearings, to avoid virtual hearings. But if we look at it from a real practical approach, frankly, I can't remember when was the last time I had a witness under cross-examination who cracked on the stand and said, "Oh, damn, I'm sorry, I made a mistake." That never ever happens. You make it in submissions and you make it out of comparing what he has to say against what the document says. That's it. Of course, there are some cases where physical appearance is necessary, where you have exhibits which require a physical inspection, or where, as in one English case, I think it was, where the judge says, I need to observe the mother's demeanor when she's sitting even in the public gallery while the other witnesses are giving evidence against her. So in that instance, perhaps a physical hearing cannot be avoided. But the point I make is this: it need not be one or the other. It can always be a hybrid. And imagine the amount of time and cost you will save if 9 of your 10 witnesses can go on, can give evidence virtually, and that 1 or 2 witnesses that you think must appear in court to be broken down or to be seen crying, limited to the 1 or 2 witnesses. With that, obviously efficiency is improved, and it also allows a better way to case manage. Now, if I'm going to have a case management or preliminary hearing in an arbitration virtually, it's no different from a phone call. So if I get an email from parties yesterday saying that there's a disagreement as to a discovery, a specific discovery request, and that concerns, say, 2 or 3 documents, there's nothing stopping me from saying, look, I'm available tomorrow at 5 p.m. Let's dial in at 5 p.m. tomorrow just to address this 2 or 3 points. And we get it out of the way, the hearing goes on, the bundling of documents go on. But if we insist on physical hearings, we've got to be realistic about it. You don't get everybody into a room, whether it's an arbitration or you haul everybody to court just to address 2, 3 points. It's a complete waste of time. But at the same time, you don't get things moving unless you resolve those points. So those are the takeaways that I have, I think, from experiences in virtual hearings in arbitration as well as in court. But to round it all up, if you ask me whether online advocacy or virtual hearings are here to stay, I say yes, certainly from the arbitration experience. And so far as court is concerned, I certainly hope so. Back to you.
Excellent. Thank you. Thank you very much, JL. Look, you raised the subject of screen fatigue, and I guess in the interest of time, we should think about concluding very soon. But I do want to just finally ask our entire panel if they have any final thoughts or comments, or perhaps want to address questions to each other. I'll give a moment for anyone to speak or raise any follow-up to what JL has said.
May I go first?
Please do, yes. I saw you turning your microphone on, Judge, so I assumed you were about to speak. Please.
No, I was just obeying instructions that we all turn our mics off when others are speaking. Thanks, James. I want to thank everybody for their generous sharing. And this is exactly what I said, that as the pandemic has just seen an outpouring, a generous sharing of knowledge and skill without restraint. I've learned so much from it. And actually it is from ADR that I picked up a lot of tips that I then implemented in the construction court, and then subsequently went on to use it at the appellate level. The remarks I just want to make is that the judiciary, just listening all round, some of the questions that have been asked or chats that have been raised have been addressed, and I think JL has also answered it. The judiciary have adopted and we have adapted, and I think we have done it well. And what has happened is that I think it's a realization all round that if you don't, we would be digitalized or digitized. And what we also have learned is that the only way we have been able to surmount it and make technology work with us is to be very firm about it, that the judiciary has to be very, very firm, and we have been. And out of this firmness, we've seen cooperation all round. And without this firmness and this cooperation, we couldn't have come this far. And I think I can answer JL's question that at the end of the day, as far as virtual hearing is concerned, while ADR looks at confidentiality, the courts in-camera proceedings aside are now thinking about how do we deal with the open court requirement, whether we should live stream every proceeding, or is there any other way around it? But we have decided, I think I can indicate this far, that virtual hearings, online hearings is not for the pandemic. It was already an option. It's just going to be a larger option next year. And I can imagine the 10 courtrooms here in Putrajaya, where the appellate courts are, being used for both physical hearings as well as online hearings. I can imagine a lot of fatigue around. We just need to find better ways of conducting this trial. I want to say thank you very, very much to my colleagues who have contributed with their insights and their input. I also would like to take this opportunity to thank my registrar, who's done some research, wonderful research, in order to prepare for this webinar. I want to thank Legal 500, if I may, and for everybody on this panel. It's a show of strength. Thank you so much.
Thank you so much. Thank you so much. Does anyone else have any final comments or thoughts?
If I can just a few thoughts. I think what this pandemic is demonstrating, it's really the importance of a good leadership in a crisis. And I think all of the speakers here today sort of have demonstrated and given different examples of this. It was, Father Justice mentioned firmness and cooperation. That is certainly part of that good leadership. And I do think also it requires a bit of courage, because we are all navigating a new landscape. And in all different levels, on the national, regional, but also on a corporational level, we have seen examples of how good leadership continues to take us through this difficult situation. And it's very encouraging to see that, again, the cooperation is so high up on the agenda for so many of the actors in this new landscape. So I think that is really, really reassuring going forward.
Excellent, thank you. And can I ask you, just as a follow-up, that I came across an SCC blog post you wrote recently on resilience. I think you discussed resilience in reference to the mindset of sailing, but I thought it was a wonderful discussion. Can you just very quickly summarize this for us? I think it would be of benefit to our audience.
Yes, well, I'm glad you read the blog post. So this was from some reflections from this spring. And so we were all here at home, and it just turns, we are sailors in my family. So I've been sailing with my husband and my family for forever. And things were closing down, and it was sort of this crisis mood we were going through, all of us. And independently of one another, me and my husband, we realized we were all thinking about sailing. So for those of you who know sailing, you know that if you're out there for several weeks, you don't think about the weather on Thursday next week, you think about the weather tomorrow, and you adjust yourself through that. And sometimes you have to adjust yourself in the middle of the night, and you just have to go up there and shift your moorings. And it's very helpful just to narrow down the perspective and just do what you can do to make things better here and now. And that's really what this crisis was all about. And now, as the number of cases are increasing in so many places, I get the same sense coming back that forget about what's next week or 2 days from now or whatever. Just do what you can now and make sure you have your right moorings now, make sure you have everything in place, make sure everyone is okay, make sure your operations is functioning tomorrow. And that's fine. You don't need anything else. You don't need to worry about everything else. And also in that middle of that sort of storm, if you want to call it that, there's this great sense of security, because we know what we're doing. We have great teams. We have really good ships or boats or sails, and we have done this before. We know what we need to do, and once we have done it, we're fine. We will be fine, and the weather will shift, and the sun will come out. So that's just basically what I'm trying to communicate with the resilience in a crisis.
That's great. Look, thank you all very much. I think we really should wrap up in the interest of time. Thank you to all our speakers. Thank you to Justice Mary Lim. Thank you to Barry Yao and Jun Liang Fu of GAN Partnership. Thank you to Ilya Hashim of My IPO. Of course, thank you to Kevin Nash of SIAC and Annette Magnuson of the SCC. Thank you all. I wish we had some Jackson Brown or Tracy Chapman to play you out with. It would certainly please the judge, but unfortunately not. So I will just close that. Thank you all.
Thank you, Jay.
Thank you. Stay safe.
Thank you.
Thank you.